You can see. Right. Sarah, please record the lecture, Sarah.
Already.
Oh yes, you're already recording it. Thank you very much, Sarah. Right. Okay. Assalamualaikum and good morning, ladies and gentlemen. I am Umi Hani and I am a lecturer in international law at the Faculty of Law, University Technology Mara. I am happy to welcome you to this online roundtable discussion. This event is a joint initiative between the Faculty of Law, University Technology Mara, and the International Committee of the Red Cross. The topic this morning is humanitarian norms and non-state armed groups, the law and practice in Malaysia. The purpose of the discussion today is to understand the nature of non-state armed groups and the strategies in dealing with them in Malaysia and under international law. Several questions arise on the application of international and domestic rules on the non-state armed groups. What does it take to be a non-state armed group? How about their status under international law and domestic law? What are the rules at the international and domestic level regulating non-state armed groups? To what extent they are required to fulfill their human rights obligation, and how do we engage them to comply with humanitarian norms? We have a distinguished panel today to discuss these questions. Allow me to introduce our esteemed speakers today briefly. I will skip the presentation in details of their impressive background. Firstly, Dr. Aisyah Ui Abu Bakar is a senior lecturer at the Faculty of Humanities, Arts and Heritage at the University Malaysia Sabah. Secondly, Associate Professor Dr. Muhammad Isham bin Muhammad Kamal is a lecturer at the Ahmad Ibrahim Kuliah of Laws, University Islam Antarabangsa. Thirdly, Dr. Pardes Muslim Zadeh Tehrani is a senior lecturer at the Faculty of Law, University Malaya. Fourth, Colonel Azlan Iskandar bin Abdul Ghani, or Mr. Jack. He was the former director of the Center for Military and International Humanitarian Law, National Defence University of Malaysia. Currently, he is working as a delegate for military and armed groups of the ICRC based in Kuala Lumpur, covering Malaysia, Singapore, and Brunei. And finally, Mr. Dominic Earshaw. He is the Regional Coordinator for Humanitarian Affairs of the ICRC based in Jakarta. He is responsible for overseeing the ICRC's relations with Islamic and Christian religious circles in Asia, as well as advising ICRC delegations on their interactions with non-state armed groups. Now, before I call upon our first speaker today, let me once again go over a little bit of housekeeping. Firstly, kindly switch off your audio and video function at all times to ensure a smooth running program. Secondly, please write down your question in the chat box for our question and answer session. I will share the question with the speakers later. And lastly, please fill in the registration form. We have provided the link to the registration form in the chat room. On that note, ladies and gentlemen, without further ado, presenting to you Dr. Aisyah. She will speak on assessing the need to define and identify non-state armed groups for classification of armed conflicts and applicability of international humanitarian and human rights law in Malaysia. Over to you, Dr. Aisyah.
Okay, thank you very much, Dr. Umi. Assalamualaikum, everyone. Selamat pagi. And thank you for inviting me as one of your resource speakers for today's topic on IHL together with ICRC. Okay, before we start, I'd like to clarify that given that we have, a good number of resource speakers who are also very much knowledgeable, and the way that this program has been arranged is that, we're very specific to our topic. So I will mainly talk about the criteria of how do we identify non-state armed groups or NSAGs. And I will leave it to the other speakers in terms of explanation for application of IHL and other legal instruments, also including in Malaysia. So does everyone hear me clearly?
Yes.
Just to check. Okay. So first of all, I want to show you the first slide. It's an exercise that we are not doing now, but instead, I just want to flash it in the beginning so that you are familiar with these terms. So basically, what we hope to achieve during this session is that we want to be able to identify clearly who are the non-state armed groups, okay, at the end of this session. So these are the names that maybe some of you would normally read on the newspaper, on online media, and maybe you watch on television. And so just for maybe if it's possible, you can take a picture of this slide. Okay, but we will go back to this exercise later on. Okay, so next slide, please. Okay. So for today's topic, as I mentioned, I will be discussing to you on how do we get to identify who are the non-state armed group. Okay, I will skip to the part on describing what is international armed conflict and non-international armed conflict, IAC and versus NIAC, because I assume that, given that you are all law students, I'm sure that you have already had this session on clearly defining the kind of situation where international humanitarian law is applicable. So I'll go straight to discussing non-international armed conflict. Next slide. Because this is where we are identifying our subject, the group of non-state armed group. Okay, so just a review quickly about non-international armed conflict. Okay, what does this mean? Clearly, can you click on the slides? Okay, just click everything, please. Okay. So we know for a fact that when we are talking about non-international armed conflict as a situation, we are dealing not only an armed confrontation with government forces, but also with non-state armed groups. Not only one, or could also be more. The important thing is that you have on one side the government armed forces, and the other side you have non-government or non-state armed groups. Okay, and then when we talk about what happens during a situation of NIAC, the description under international humanitarian law is that the hostilities or the armed confrontation itself must reach a minimum level of intensity. It's kind of a general description when you say hostilities must reach a minimum level of intensity, because what does it really mean when we say minimum level of intensity? But I guess the succeeding descriptions is that the intensity of engagement, of armed engagement, it's not only one or two, but it's really a regular armed confrontation engagement. And of course, there will be casualties, in the event of all these armed confrontations. And of course, the subject actor for this type of situation will include non-state actor or non-state armed groups. Okay, and then these non-state armed groups, as expected, they should also be using hardware weapons. Okay, and that they have been, as I mentioned earlier, in confrontation with government forces for a number of period, not only one time or twice, but it has been there is consistency, there's a regularity of engagement. Okay, and then just before we go to the next slide, I also want you to remember that in international humanitarian law, we have this label called non-state armed group. Okay, it can also sometimes, be identified as non-state actor groups. Okay, but in other fields of studies, I just want you to be conscious that in international relations, for example, non-state actors can also be used to refer to non-government organizations. Okay, so I want you to be very clear on that. But because we are in the field of international humanitarian law, when we refer to non-state actors, we refer to those armed groups, non-state armed groups. So that is something that we have to take note. Okay, next slide, please. Okay. The guidance on describing, putting more identification of who are these non-state armed groups, okay, came about in one of the cases in Yugoslavia, okay, in 2008, and they added all these 5 elements on how do you identify if this organization is a non-state armed group. Okay, one is that they should have a command structure. They have a military and hierarchical structure. And then, of course, they carry out their operations in an organized manner. It's not something that today they decide to do an attack. Tomorrow they might not do an attack, but it's all part of really a machinery, a military machinery unit. And that armed confrontation is done as a tactic, as part of their tactic and strategy to carry out an agenda, a political agenda. So that is something that has to be clear also. And then, of course, that will include that they do have a level of sophistication with respect to logistics. They do have a constant supply of ammunitions, of everything that they need, not only ammunitions, but even human resource, including financing and all that. And that within their armed forces, we cannot say that they are just a ragtag armed forces, that they are just, organized out of a sudden. But, these organized military or armed group, rather, they do impose an internal discipline. Okay, they are trying to be a professional armed group. Okay, as a fighter, as a combatant. Okay, vis-a-vis with the military, which is a government force. Okay, and of course, as I mentioned earlier, they do have an agenda, a political agenda that they want to achieve. That's why they form this armed group, and that they speak with one voice. Okay, so they represent themselves as an important actor, for their political agenda. Okay, next slide, please. Okay, and then when we look at the additional protocol 2, okay, they also clearly states there that, just again to reiterate, that these in a situation of a non-international armed conflict, as I mentioned, you have to have government forces, okay, on the other side, and a non-state actor armed group in the other side. Okay, and that these non-state actor groups or armed groups should also be in a territory. They have a control over a territory. Maybe not total control, but to a certain extent, they are able to wield their political power and their military power. They are in a way very influential, and they do impact the security condition in that area. That is why they are an important actor when it comes to international humanitarian law. And then I'm already mentioned earlier also that they do have a political agenda. They have a minimum level of organization. And then they're fighters, as they want to be looked at as a professional fighting organization. They do wear uniforms to identify themselves. Okay, because of course, when you are in an armed confrontation with government, you want to clearly identify who are the ones in the government, military force in the government, and who are they as a non-state armed groups. Because of course, what happens when you are in a war zone? You have to clearly identify yourselves. And then because of these kinds of description of a non-state armed groups, then other internal disturbances and tensions organized or done by some other groups, like smaller groups, are not put under, they cannot be classified as doings of non-state actor groups, but they can be part of acts of banditry by other groups. Okay, and this is something that we will have a better notion later on. Okay. Okay, next slide, please. Okay, we'll go back to the exercise because I think this is really where, you will have more clarity. I've given you some description, maybe not 100% yet sinking into your minds, but perhaps going through this exercise, then you will have a better idea on how do you actually put the check, in some of these names. Okay, how do we do this? Okay. Is there a way? I don't think there's a way for us to do like interaction, right, for the participants. But just looking at the names, okay, I want you to take note and try to list down in your own notes, okay, whether these groups are non-state armed groups or if they are not. And if they are not, what are they to you? Okay, so I'll mention Fretilin. Okay, Fretilin is from Timor-Leste. Okay, Karen National Union, Kachin Independence Organization from Myanmar, Communist Party of Malaysia, okay, the Patani United Liberation Organization, or PULO from Thailand, the Moro National Liberation Front from Philippines, the Kidnap for Ransom Group, normally to refer to groups from the Philippines, Organisasi Papua Merdeka from Indonesia, the Free Aceh Movement or Gerakan Aceh Merdeka or GAM from Indonesia, the Liberation Tigers of Tamil Eelam, the Abu Sayyaf Group, the Moro Islamic Liberation Front or MILF from Philippines, the Communist Party of the Philippines, the Front Pembela Islam or the Front of the Islamic Defenders from Indonesia, the Arakan Army from Kachin State from Myanmar, Al Mauna from Malaysia, All Burma Students Democratic Front, the Shan United Revolution Army, the Chin National Army, the Barisan Revolusi Nasional from Thailand, Arakan Rohingya Islamic Front from Myanmar, and an ISIS cell in Malaysia. Okay. I don't think we can do any interaction or a polling, right? So I will just, quickly explain to you these names. Okay. Fretilin is a non-state armed group from Timor-Leste. So that is clear. And they've been successful in liberating Timor-Leste and they were able to have freedom in their country. Karen National Union, the Kachin Independence Organization, Arakan Army Kachin State, the All Burma Students Democratic Front, the Shan United Revolution Army, the Chin National Army, and the Arakan Rohingya Islamic Front are all non-state armed groups from Myanmar. Although there are more non-state armed groups in Myanmar, but in the ongoing peace process, there are only 14 peace processes that is ongoing in Myanmar. And this doesn't include the Arakan Rohingya Islamic Front. Okay. And then from Malaysia, the Communist Party of Malaysia, of Malaya rather, okay, was a non-state armed group. Okay, but for Al Mauna, this is not a non-state armed group. Okay, because they did not reach that level of non-state armed group criteria. Okay. And then from Thailand, the Patani United Liberation Organization and the Barisan Revolusi Nasional are just two of the seven non-state armed groups from Thailand. Okay, and then from Indonesia, we have Organisasi Papua Merdeka from Papua. So this is also a non-state armed group. The Free Aceh Movement, or GAM, or Gerakan Aceh Merdeka, is also a non-state armed group who have signed a peace agreement with the Indonesian government, and they have been able to govern Aceh today. But another Indonesian group, the Front Pembela Islam, or the Front of the Islamic Defenders, this is not a non-state armed group. Although we may read about them in the newspapers, they do, a lot of mobilization, and they can be radical in their means, but nonetheless, they are not a non-state armed group. Okay, from Philippines, we have the Moro National Liberation Front, which was the first Bangsamoro armed group, non-state armed group. Okay, and then we also have the Moro Islamic Liberation Front, or the MILF, and both have signed peace agreements with the Philippine government. Okay, and the Moro Islamic Liberation Front agreement has been brokered, in fact, by the Malaysian government. Okay, and a third group from the Philippines is the Communist Party of the Philippines. This is also another non-state armed group from the Philippines, which is also have an ongoing peace process. And this communist group is only one of the 4 communist groups in the Philippines that continue to be a non-state armed group. Okay. Another is the Abu Sayyaf group. Okay, this can be tricky. Okay, definitely they are not a non-state armed group. Okay, because they do not, they cannot be categorized similarly to MILF, MNLF, and the Communist Party of the Philippines in terms of the political agenda, because they do not have a clear political agenda. Okay, and in terms of organization, military organization. Okay, in the beginning, in the 1990s, the Abu Sayyaf group became prominent because of their kidnap for ransom activities. Okay, that includes kidnapping in Sipadan in Sabah. Okay, but in the recent times, in the last 5 years, slowly the Abu Sayyaf, or the last 10 years rather, the Abu Sayyaf has been implicated, by some of the governments to be part of one of those groups that conduct acts of terrorism. Okay, I will be very careful in labeling them as a terrorist organization, because we know that under international humanitarian law, we do not have an agreement of what is a terrorist organization. But instead, we do refer to groups who are implicated in acts of terrorism. So Abu Sayyaf group is one of those groups that are kidnap for ransom group. At the same time, they have been identified as been a doer of acts of terrorism. And then another group that also come out from studies in terms of security, just like here in Sabah, I'm sure you read some news or reports about kidnap for ransom group that are present from southern Philippines, and that have been involved in activities in Sabah. So again, this group, KFR, they are not a non-state armed group. Okay? Instead, they are a criminal group. Okay? And then what else did I miss? ISIS cell in Malaysia. So similarly to Abu Sayyaf group, these are groups that are implicated in acts of terrorism. Okay, and they cannot be put under the same level with non-state armed groups, because they do not have a clear military presence. Okay, in Malaysia. Okay, what else? Yeah. Okay, that's it. Okay, can we go to the next slide? So this is why, just quickly, I also want to just put up this last slide. So now that we know who are this non-state armed group, if we are able to identify them clearly, then we also know what are the applicable IHL laws that we can apply for these groups. Okay, so these are the specific application of IHL, and this one will be discussed later on by the succeeding resource speakers. Okay, so I'll leave it at that, and I think I have just one slide. Okay, the last slide. Again, just to go back about the situation of international armed conflict and non-international armed conflict, and where the non-state actor groups, they are our primary subjects or actors in a non-international armed conflict. And so from this presentation, I hope that you can continue practicing and learning how to identify who are non-state armed groups. Thank you. And I give it back to you, Dr. Umi.
Thank you very much, Dr. Aisha. That is very helpful in understanding the identity of non-state armed groups. Again, to the attendees, if you have questions, please write your question in the question and answer chat box. All right. Now, we are going to continue our discussion on the legal regimes applicable to the non-state armed groups. I would like to invite Professor Hisham to speak on assessing the application of international humanitarian law to non-state armed groups in Malaysia under domestic legislation and Malaysia's international obligations. Over to you, Professor Hisham.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And good morning. Thank you, Dr. Umi. Also like to thank UITM and ICRC for inviting me to be a panelist for this seminar, roundtable discussion. Okay, the topic that I have been asked to discuss is assessing the application of international humanitarian law to non-state armed groups in Malaysia under domestic legislation, as well as under Malaysia's international obligations. I'll start with the Geneva Convention first. 1949, Geneva Conventions 1949, demand that states parties teach IHL to their armed forces and the general public. Okay, the Geneva Conventions demand state parties to criminalize war crimes, and in case of the commission of such crimes, to investigate and punish the crimes. Now, how is the Geneva Conventions applicable to the international armed conflicts and non-international armed conflicts? This is in the next slide. Sister Sarah, okay, thank you. Okay, the 4 Geneva Conventions are applicable in international armed conflicts. Okay, and however, there is the common Article 3. In case of non-international armed conflict, civilians must be treated humanly, where violence to life and person, taking of hostages, outrages upon personal dignity, and extrajudicial punishment are prohibited, as well as the wounded and sick must also be cared for. Okay, let's look into how Malaysia applies the Geneva Conventions 1949. Okay, Malaysia is a party to the Geneva Convention and has enacted Geneva Conventions Act 1962. Okay, and one thing, if we look into the Geneva Conventions Act, we'll find that all the 4 Geneva Conventions are listed in the schedule. Sister Sarah, can you move to the next slide, please? Thank you. Okay, and okay, so I'm not really sure what is the implication, what is the legal implication when the 4 Geneva Conventions are listed in the schedules. From the wordings of the provisions of the Geneva Conventions, I couldn't figure out what is the implication. And this is quite different from later practices by Malaysia. For example, when we become a party to the Vienna Convention on Diplomatic Relations, 1961, we enacted Diplomatic Relations Vienna Convention Act, and then we copied some of the provisions of the Vienna Convention into that particular act, word for word. But not every single provisions of the Vienna Convention on Diplomatic Relations Act, Vienna Convention on Diplomatic Relations. But the provisions in the Vienna Convention, VCDR, are copied and legislated in the provisions in the texts of the Act itself. But here in the Geneva Conventions Act, we put the whole 4 Geneva Conventions in the schedule, and there is no provision in the Geneva Conventions Act that say that the 4 Geneva Conventions, as it is listed in the schedule, are applicable in Malaysia. Okay, so I'm not really sure what will be the implication. However, we should take note that Section 3 of the Geneva Convention Act criminalizes grave breaches. Okay, take note of the wording. Criminalizes grave breaches of the 4 Geneva Conventions, as is referred to in Article 50 of the Geneva Convention 1, Article 51 of Geneva Convention 2, Article 130 of Geneva Convention 3, and Article 147 of Geneva Convention 4. And Section 3 also provide imprisonment, provide imprisonment as the punishment. Okay, so this is in relation to Geneva Conventions 1949. Okay, regarding additional protocols in the next slide, 1977, I want to focus on the additional protocol 2 that is applicable in non-international armed conflict. And Malaysia is not a party to the additional protocols 1977, including the additional protocol 2. And Malaysia has not enacted legislation relating to conduct of belligerents in non-international armed conflicts. Okay. Can you move to the next slide, Cik Sarah? Okay. Now, earlier, I have referred to the Section 3 of the Geneva Convention Act providing for grave breaches. Okay. From research, I found that basically authors are arguing that grave breaches occur only in international armed conflicts. Okay, their references would be the 4 Geneva Conventions, and the additional protocol 2 do not contain provision relating to grave breaches in non-international armed conflict. And if we refer to Article 8 of the ICC Rome Statute, yes, it also mentioned grave breaches in non-international armed conflict. There are also violations in international armed conflict. But with regard to non-international armed conflict, there is no wording of grave breaches. So I'm of the opinion that Section 3 of the Geneva Convention Act does not apply to non-international armed conflicts, and therefore cannot be used to punish a belligerent, okay, who violates international humanitarian law applicable in non-international armed conflict. So the Section 3 Geneva Convention Act is not applicable in non-international armed conflict. You cannot be punished belligerent who violates the IHL, whether the belligerent comes from the armed forces of Malaysia or from non-international armed group. Next slide. Okay, with regard to customary international humanitarian law applicable in non-international armed conflict, we can argue that the principles in the additional protocol 2 are material evidence of customary law, among other things, based on the argument that there are 169 state parties. So the acceptance is widespread, and the practice has also been quite consistent on this matter. So customary IHL is binding on Malaysia, okay, though Malaysia is not a party to the additional protocol 2. Okay. Now, in the event of a non-intentional armed conflict in Malaysia, the armed forces of Malaysia must observe the customary IHL as evidence in the additional protocol 2. However, there is no legislation that criminalizes violation of customary IHL applicable in non-intentional armed conflict. Reference to the Armed Forces Act 1972 finds that the Act only punish service offences by the members of Armed Forces of Malaysia, such as insubordination. Okay, let's look into application of customary IHL on non-state armed group. Non-state armed group must observe the customary IHL. Okay, we can argue that in the event a rebel group succeeds in replacing the government, okay, or in establishing a new state, then the government and the new state is bound by the customary IHL. So legal obligations afforded to this group after such a victory should also apply to them when the hostilities are still in progress. So this is how we can argue that the non-state armed group, how they should observe the customary IHL. If, let's say, if the state has accepted the additional protocol 2, okay, is a party to the additional protocol 2. So if the rebel group manage to topple the government, they are bound by that particular treaty. So in the process of hostilities, they should already observe the law. However, when I'm referring to Malaysia, because Malaysia is not a party to the additional protocol 2, but we are bound by the customary IHL. So even if a rebel group succeeds in replacing the government, okay, by the time they become the new government, they are bound by the customary IHL. So during the process of hostilities, okay, they should be also bound by the customary IHL. Okay, right. Let's look to the next slide, please. Okay, now this is a general point. I'm not referring to any research, particularly in Malaysia. I have not done that. Sometimes it's quite a problem for the IHL to be accepted by non-state armed group. Okay, among the reasons is there is lack of involving non-state armed group in the making of the law, and to reduce the non-acceptance probably require more dialogues with the non-state actors. And certain Muslim armed groups, there have been research on this with regard to some Muslim armed groups in other places, may consider themselves as not having obligation under the modern IHL. Okay, some groups may consider the modern IHL human-made, not God-made, and therefore they deem violations of IHL to be justified on the basis of the Islamic law as they understand it. Okay, okay, probably we can see what have some of the activities by the certain groups such as the Islamic State of Iraq and Syria. Okay, sometimes they try to justify what they do, okay, by their reference to the Quranic verses and their interpretation. Although some other scholars such as Al-Qaradawi has condemned the act as un-Islamic, for example, but they still considered their interpretation to be the correct one. And one thing is they do not want to accept modern Aishal, customary Aishal, on the ground that is not Islamic, it's not made by God, it's made by human being. We need to have more discussion on the compatibility of modern Aishal with the Islamic law to address this issue. Okay, and the next slide is relating to the need for legislation in Malaysia to punish violation of customary Aishal. We have a principle from international criminal law, even I believe that this principle is also from the domestic criminal law. There is no punishment without a law. Okay, currently there is no legislation prescribing the punishment for war crimes in non-international armed conflicts, and therefore Malaysia must enact law providing for such punishment. Okay, let's look into the effect of non-legislation. The next slide, please. Okay, now, if we do not have legislation criminalizing war crimes, should war crimes are committed in non-international armed conflict in Malaysia, and Malaysia does not punish the perpetrator appropriately, Malaysia will be responsible for not observing its customary Aishal obligation. Okay, for example, if a member of an armed group who has targeted civilians is tried only under Section 121 of the Penal Code for waging war against the king, and or under the Firearms Increased Penalties Act 1971, it means that the bellicgerent is not tried for the war crimes that he has committed, targeting the civilian. Okay, that's all my my presentation, my slide. Thank you very much.
Thank you very much, Professor Hisham, for the stimulating reflection on the rules applicable to the non-state armed groups. Apart from the IHL, human rights law is also applicable during armed conflict. On that note, I would like to invite Dr. Pardis to speak on the application of human rights law to non-state armed groups in Malaysia. Over to you, Dr. Pardis.
Good morning, everyone. Thank you, Dr. Omi, for my invitation, and thanks ICRC. Today's topic I'm going to talk about and discuss about the application of human rights law to non-state armed groups in Malaysia. Let me start with some general information on non-state armed group. A long list of non-state armed groups attack on different parts of the world indicate how non-state armed groups affect human security. And studies on organized crime have proliferated in these past years and reflecting the spread of this phenomenon to all countries. And the impact, definitely the impact is so significant that the violence resulting from this situation exceeds many ongoing civil wars and armed conflict. A recent quantitative analysis of global violence indicates that only 1 out of 10 killings is a result of terrorism or armed conflict, and more than 3/4 of worldwide fatalities occur in non-conflict settings. I'm starting to discuss about the abuse or violation of human rights, and what does it mean by abuse or violation. The UN Security Council has not explicitly defined what constitutes as an abuse or violation of human rights regarding to non-state actors, and nor are these terms uniformly defined as such in international human rights law instruments. But generally, obligations and duties assumed by states under international human rights law treaties are often characterized as obligation to respect, protect, and fulfill human rights. And according to the United Nations High Commissioner for Human Rights, the obligation to respect requires refraining from interfering or with curtailing the enjoyment of human rights. The obligation to protect requires protecting individuals and groups against human rights abuses, and we have the obligation to fulfill, which means that positive action must be taken to facilitate the enjoyment of basic human rights. And could you go to, yeah, I can see that's fine. It's worth mentioning that non-state armed groups are bound by the law of armed conflict, which have been stated by Prof. Hisham as well. But the extent to which these actors have obligation under international human rights law still remain controversial. And various international and regional bodies have recognized the applicability of international humanitarian law in both international and non-international it's been argued that the objective of human rights treaties is to establish norms for regulating the relationship between states and individuals living under their jurisdiction. And in consequence, human rights treaties are neither intended nor adequate to govern armed conflict between states and armed opposition groups. However, the interpretation of human rights law have not been unanimously supported by different scholars, and the argument human rights law that apply to non-international armed groups is problematic, is a little bit problematic for several reasons. First of all, IHL is limited to acts directly associated with armed conflict and not partially address the range of harmful action that occurred and perpetrated against civilian population by non-state armed groups. And second, IHL regulates armed conflict and limit their negative impact on victims and those who have laid down their arms. And definitely, it doesn't cover all violations of international law that occur in this situation. And another point is that IHL may not apply in situations where its condition of applicability are not fulfilled armed conflict. And in such cases, the only remaining legal framework other than domestic law is human rights law. And, sorry? Okay. Doctor, we are still on slide number 2. I didn't go through slide number 3. And besides that, I need to add that the applicability of international norms to non-state armed groups has been reinforced by judicial decision of international, regional, and national courts. And the practice of UN bodies such as UN General Assembly, UN Security Council, United Nations Commission on Human Rights, and so many other bodies. According to the practice of these bodies, non-state armed groups are bound to apply the obligation of both international humanitarian law and also international human rights regarding the right of persons affected by armed conflict. All these state-centric perceptions are based on the approach of international human rights law and the language used in the treaty of international human rights law, which give preference to states as human rights treaties created by the states. This is due to the fact that the initial development of international human rights law was to regulate and restrict the power that states have over the rights of the individual. In order to fulfill these obligations, states take necessary steps to modify, necessary steps to modify their domestic institution and domestic law in accordance with international human rights law standards. And states needs to discharge their international obligation by incorporating many international human rights law provisions into their constitution and setting up monitoring mechanism to ensure the implementation of these rights at the domestic level to safeguard the rights of their citizens. And therefore, this is a procedure which needs to be adopted by Malaysia. As you know, Malaysia has not ratified most international human rights covenants and treaties. And even the treaties that are ratified are not self-executing. In fact, Malaysia is a dualist system and follows the doctrine of transformation. And Malaysian courts applied international treaties to which Malaysia is a party, provided that the treaty concerned has transformed into Malaysian law by means of statute made by the parliament. And it's necessary to emphasize the need of the coordination and cooperation among all three organs of the state, namely judiciary, executive, and legislature. Out of these three organs, the executive appears to have a pivotal role, since according to Malaysian constitutional law, it's possesses treaty-making power and also has a power to submit and to draft the statutes to Parliament. And whenever a treaty which affects the right of the Malaysian or requires a charge of Malaysian to domestic law has been ratified or acceded to, or the executive must make every effort to prepare without delay in a draft enabling the statutes and submit it to Parliament to make the rule. Only in this way can Malaysian courts apply international treaties and conventions effectively through enabling statutes. International law is not law per se for in Malaysian system, as I said, because it's dualist system, and the reception of international human rights law in national courts sometimes poses many legal problems. As Malaysia has not ratified so many human rights treaties. Slide, please. Slide number 3, sorry, number 4. As is stated with the Universal Declaration of Human Rights, the obligation of every individual and every organ of society to implement the human right, and this idea has been incorporated in the preamble of the 2 components of ICCPR and ICSCR, and Article 29 of the Universal Declaration of Human Rights stated that everyone has duties to community in which alone the free and full development of his personality is possible. And we have some, in these slides, I listed down the international human rights treaties and the development of the new human rights treaties. The newer developments of international human rights law paving the way to include non-state armed groups in its scope. This is clearly visible in the new human rights treaties that have been developed over the past years, and including CRC, Optional Protocol of Armed Conflict, and Kampala Convention, which Malaysia has ratified the CRC, and it can be applied as substances of international human rights law. The optional protocol approved by the Commission of Human Rights is the first human rights treaty that directly addresses non-state armed groups. As it's increased the age of children participating in hostilities directly in the recruitment of the children into armed forces from age 15 into 18 years. From its original convention of CRC, which adopted in 1989. The Kampala Convention, also considered as the first binding regional instrument, and the Declaration on Minimum Humanitarian Standards. This is a very crucial document that provide concrete guidance to parties in non-international armed conflict to protect civilian. We have also here the guiding principle, which encompasses the existing international norms of IHL and also international human rights law and refugee law to offer the protection, legal protection for displaced person. And customary international law, which is really important, source including peremptory norms of international law in applying and incurring obligation to non-international armed conflict, to non-state armed groups. And a number of sources of customary international law include obligation to non-state armed groups, irrespective of their legal status. Art and definitely the peremptory norms are non-derogable under any circumstances, and it's yes, and according to Article 4 subsection of the ICCPR, it's the non-derogatable rights have been listed. Next slide, please. Another international bodies which is important for application international human rights law to non-states armed group is United Nations Security Council and United Nations General Assembly. UN General Assembly, United Nations UN General Assembly and UN Security Council both address potential human rights abuses and violation, as well as potential human rights obligation and other responsibility of non-state actors, non-state armed groups. However, certain differences emerge between the approaches of UN General Assembly and UN Security Council. These differences may concern relevant geographic focuses, as well as emphasize on addressing some non-state armed groups. Also, the legal bindings of UN General Assembly resolution may distinguish them from certain relevant UN Security Council resolution. The question which arises here is that some or all of relevant documents legally binding, and second question is that if the document is considered binding, whom or what does it behind it? To answer the first question, with limited exception of UN General Assembly resolution, their own are in general considered not binding, but it might reflect emerging state practice. Some UN Security Council documents, most obviously decision expressly adopted under its Chapter 7, authority arising, all necessary measures impose legal obligation. And the use of particular language of certain legal authorities under UN Charter indicate whether the UN Security Council intends for a resolution to be legally binding. To answer the second question, if the document is considered binding, whom or what does it bind? UN Security Council resolutions are often directed at UN member states, and the UN Charter provides that its member states confer on the Security Council primary responsibility for the maintenance of international peace and security, and that member states agree to accept and carry out the decision of the Security Council in accordance with the Charter. Chapter 7 of the Charter also establishes responsibility of UN member states to carry out decision of the UN Security Council and afford mutual assistance in doing so. It's obvious that UN Security Council and UN General Assembly have recognized at a minimum that the conduct of at least some non-state armed groups in the context of different armed conflict can amount to violation or abuses of human rights. However, that either of these principal UN organs has taken sufficient steps to formally non-state armed groups with human rights obligation in general international law. And taking those steps would contribute to radical revision of a key conceptual foundation of international human rights law system. UN Security Council and UN General Assembly action in support of such a development would ultimately be seen as promoting greater protection and enjoyment of human rights and accountability of the non-state armed groups concerning violation of human rights. And as you can see, by these two, especially with UN Security Council and UN General Assembly, condemned the violation which have been occurred by non-state armed groups, and based on the resolution which have adopted by UN Security Council, non-state armed groups needs to comply with the international human rights law. And next slide, please. Here in this slide, you can see some of the specific human rights obligation of non-state armed groups, which is important, and non-state armed groups are obliged to comply with these rules, such as a human rights obligation of non-state armed groups, especially in situations when they have control over a territory which labeled as de facto regime, and the other obligations which have been listed down in this slide. Next slide. Regarding the responsibility of non-state armed groups, international criminal law established the criminal responsibility of individual members of non-state armed groups when international crimes have been perpetrated, including international crimes not committed in the context of armed conflict, and which are therefore outside the scope of the international humanitarian law. Examples could include the crime of genocide and crime against humanity in situations in which massive and criminal human rights violation occur. In general, states are not responsible for acts committed by private entities or persons. However, in certain circumstances which have been listed down here, states can be legally responsible for an international level of violation of international law, a violation of international law, which have been committed by non-state armed groups. And first, when a state has exercised control over non-state armed groups, and such that non-state armed groups, in fact, their acts must be under its direction, under the direction of the government, and non-state armed groups has exercised elements of governmental authority in the absence or default of official state authorities in some circumstances where it was necessary, and a non-state armed group has become a new government, and the state then assumes responsibility for violation of the non-state armed groups committed before it assumed power. For the case of Malaysia, as we are aware that we have SOSMA and some other regulation which have been adopted according to the international convention, which have read the current legal framework applicable to non-state armed groups present an acceptable accountability and protection. In 2009, UN Security General observed that we need to urgently develop a comprehensive approach toward improving compliance by all these groups with the law, and encompassing actions that range from engagement to enforcement. All the statistics and research which have been done by different scholars has shown that non-state armed groups can be accommodated as subject of international human rights law without treating them as to states. And non-state armed groups are not bound by full range of human rights law, but to a threshold of norms derived from the nature of their control and degree of organization or capacity. There is no evidence that the recognition of non-state groups as subject of IHL or the UN Security Council or UN General Assembly regarding non-state armed groups has resulted into their legitimization. When a non-state armed group legitimization occurs, it's not because of international legal principle, but for political reason, reflecting of international, regional, or domestic realities. And binding non-state armed groups members to human rights obligation fills existing gaps in relation to international accountability for human rights violation. And it provides a legal foundation for access to remedies and reparation for victims. Relevant international human rights treaties, because Malaysia has not ratified most international human rights components and treaties. And that's it from my point of view, and thank you so much.
Thank you very much, Dr. Pardes, for the exciting reflection on the role of human rights law in dealing with the non-state armed groups. Besides the legal framework, we are going to examine the non-legal framework in dealing with the non-state armed groups. Engaging with the non-state armed groups are essential for various purposes, such as to secure access to populations in need and to ensure compliance with humanitarian norms. We have two speakers with us today who are going to speak about this topic. Firstly, Colonel Azlan will present this topic from military and Malaysia's perspective. The title of his presentation is Engaging the Non-State Armed Groups to Respect Humanitarian Norms, Malaysia's Experience, Lessons, and Next Steps. Next, Mr. Dominic will share with us the practice of the ICRC in engaging the non-state armed groups. He will provide us with an overview of humanitarian norms and non-state armed groups. Now, I'll pass the floor to Colonel Azlan. Thank you.
Assalamualaikum and very good morning, everybody. Indeed, I find myself to be very fortunate today because I'm basically back in my alma mater. I read law in the Faculty of Law, University UITM Shalam. Can everybody hear me?
Yes, we can hear you.
Is it possible that Sarah load up my PowerPoint presentation? Is it possible?
Do you have your PowerPoint with you? Are you forward it to me?
I already emailed to Sarah and copied it to you, Dr. Omi.
Oh, okay. Let me just check for a while.
All right.
Yeah, I've sent it to you, Sarah.
Don't worry, there are only 8 slides to my PowerPoint. It's not going to be a major mental gymnastics adventure. But while we are preparing, I would like to say this. What I said by me, I have to issue a caveat. What is said by me, purely on the basis of my background in operations and armed forces legal. I do not, whatever I say does not represent the Ministry of Defense nor that of the ICRC. all those information which I've shared with everybody today, a number of them appear to be classified, but I'm able to pick up those of you where it is of very major interest to in the academic world. Thank you, Cik Sarah. All right. So now my scope of my presentation will be as per displayed. Standard. This is a standard military typology of doing things. So I proceed my scope. So I will go through definition next with type of engagement situation, discussion, and the way forward. Next. That is actually, I'm going to use an ICRC term, or the International Committee of the Red Cross term, where it is a description whereby the term being used is that of a non-state armed group, or NSAC, where those who are not under the control or command of one or more states, but have their own structure and chain of command, and are party to a situation of violence of ICRC concern. Next. So there are basically three types. This is not an academic typology. This is a field anecdote operational typology. There are three types of engagement undertaken by the Malaysian security forces. When I say security forces, they include the Malaysian Armed Forces, the Royal Malaysian Police, and the National Prosecution Service under the Attorney General's Chambers. So there are three types of engagement. One, I will divide it into engagement under an emergency situation. The second one will be that of an engagement under a typical law enforcement or LE situation. And the third one will be the engagement in a hybrid situation, whereby it's a hybrid of special legal provision and normal law enforcement engagement. Next. All right. Now, emergency situation. When we say emergency under Malaysian law, I'm sure all of you have studied the Malaysian legal system and the federal and constitutional law. That when we say emergency, means emergency declared under Article 150 of the Federal Constitution. So throughout our history, we assume there's only one emergency, i.e., that emergency declared in 1948, and that was meant to deal with the armed elements of the Communist Party in Malaya. However, in actual fact, we actually in our history about 4 emergencies. Anyway, in this particular emergency, the emergency was declared because of the activities of armed elements within the CPM. They sought to undermine the then British colonial administration in Malaya, and to impose a Marxist-oriented administration in the state then. Upon Merdeka or independence on 31st August of 1957, there was no cessation of these activities, and within the security forces, the activities of CPN were deemed to be an insurgency, and all of them were deemed to be, the terminology used on all of these members of the CPN were communist terrorists. Yeah, it sounds very weird in the legal sense by using such terms, but those were the operational terms used by the government. So the laws used for the action against the CPM during the period was actions under the power of the Internal Security Act 1960 and prosecutions or actions under the Essential Security Regulations. Next. All right. The next type of engagement was under what we call an engagement under a typical law enforcement situation. We can see this for purpose of this morning's forum. This setup was used against the Al-Mauna group, and then later this was in the year 2000, and then actions against the Jemaah Islamiyah post September 11, 2001, and also against the ISIS terrorist group. Now, for the Al-Mauna, for those who are just to recap, Al-Mauna was a group where they were composed of a number of people who ostensibly were there for, they joined this particular group for purpose of training and learning martial arts and basic principles of Islam. However, in early 2000, core members of this group, about 30 odd men actually. Under this guy, it was like a movie, you know. These guys themselves, military personnel, military officers, they came into a military camp in the border area with vehicle disguised as military vehicles, ostensibly to conduct inspection, and they managed to cut off about a huge number of weapons, small arms, and they went to a place called Geneva in Perak, and they established the position there, and they came out, and what happened was the villagers reported about the activities to the security forces. What happened was the police were called in, and the armed forces were called in to support their operations. At the end of the day, after the standoff occurred, it was cleared after about 2 weeks. All of the people there at Bukit Tenalik were arrested. They were charged under the penal code. The core members were charged under Section 121 of the penal code. 3 of them were found guilty and they were sentenced to death. Right. Others were sentenced to a few number of years of jail time, and most of them are already released. For JI and ISIS is a rather fairly recent phenomenon, but I can say that by the broad definition, they appear to be an armed group. All right, but what is very different of these two compared to the CPM is that they espouse what you call it, a non-worldly aspiration. Those in the business of counterterrorism use the term millenarian. They are a millenarian group believing in the afterlife, and existing state structures, existing institutions within the country are deemed to be sacred religious and deemed to be need to be wiped out and replaced with, in their views, a more Islamic accepted version of their idea of their version of Islam. And in this kind of situation, there was a mixture of actions under using the laws of the penal code, the Security Officers Special Measures Act, and also the Prevention of Terrorism Act. Next. This is very interesting. Engagement under a hybrid situation. When we say a hybrid situation, means that actions were undertaken under 2 sets of laws. One set would be security laws, and for Sabah, there's this particular provision, the Preservation of Public Security Ordinance of 1962, and the regulation passed thereunder in 2013. And those from Sabah, I live there, I have my home there, so we are very familiar with ESCOM, Eastern Sabah Security Command. So ESCOM is established under the Public Security Regulation of 2013. For those who do not remember, right? So what happened was, on Valentine's Day 2013, a number of armed gunmen from a neighboring country actually went to landed in a kampung or village called Tanduo in the district of Lahad Datu, located on the eastern seaboard of Sabah. And when they went there, they went to firm to ground there, and they came out with the demand that Sabah be placed under the they declared Sabah as part of the Sulu Sultanate. What happened was it was followed up by military action. It was a combined operation by both the military and the police, resulting in about 70 odd casualties. Of that number, 58 who were killed action were those from this group who call themselves the Royal Sulu Forces. 10 members of the Malaysian security forces and 6 civilians died as a result of that. Now, resultingly, a number of them were arrested. So 23 were arrested and they were charged at the High Court of Sabah in Kota Kinabalu. They were charged under the penal code, various provisions of the penal code. 9 were charged for waging war against Yang di-Pertuan Agong or His Majesty the King under Section 121 of the Malaysian Penal Code. Next. Now, this is where I would like to expand further. Now, if you can see from my brief description, what is common about all of them? Okay, one thing, insofar as the governments of Malaysia's actions, the security establishment, all of these people or these groups were deemed to be terrorists. They were classified as terrorists. And that what is interesting that for the cities of the CPM, the Sulu government, and the operators of the Al-Ma'na group wore uniforms, they had a structure, they had a hierarchy, and they had internal disciplinary mechanisms. So essentially, they were not much different from military and police personnel of Malaysia. And one thing common about these three is that they espouse a very ethnocentric or worldly expression. When we say ethnocentric, it means either they were talking about something to be achieved in their current lifetime, i.e. in establishing independence, or they're reclaiming what is supposed to be, what they presume to be lost lands, and or for a betterment, you can see that for the betterment of their people, their generations. With the CPM, when they came up with their armed struggle, Malaya was under British colonial control, so they were basically demanding independence for Malaya. But for the GI and ISIS or groups of that nature, it was more complicated. All right, they refused to accept any. They did not have any temporal or worldly aspirations. Once again, using the counterterrorism term millenarian, they were very millenarian in aspiration, i.e. that they need to achieve something in the afterlife. They must create the condition to achieve a better afterlife, and all those structures currently in Malaysia are deemed to be bid'ah or against the very essence of Islam. Thus, the imposition of law, they do not recognize any laws, any values, any structures. When we deal with them, this is where it's, in terms of when engaging with these groups are quite complicated. Next. Now, method of engagement. Right. So, I would like to give this engagement along three methods of engagement. One is kinetic action. Kinetic action means the use of force, including the force of arms, to deal with these groups. All right. So, if you notice that various types of police action or military action was undertaken, and those who were arrested eventually face the action under Malaysia's legal regime, either under the Internal Security Act, the much maligned Internal Security Act. But from my experience in my previous job, I say it was quite effective in providing security to Malaysia. However, I qualified that in the previous job, right? But more importantly, that the Malaysian government employed a number of a mixture of approaches in dealing with these people who were arrested. Now, while they were undergoing detention, while under trial or being processed for trial, psychological approaches were employed. For the GI and the ISIS, today that process is known as the de-radicalization process. Right? So it's a process undertaken by Jabatan Kemajuan Islam Malaysia or Malaysian Islamic Development Department, JAKIM, in cooperation with the Royal Malaysian Police. So one thing was interesting about this direct was that it was for those who were from GI or ISIS. Basically, the institution take the view that they are misguided Muslims. Hence, the approach is to restore their interpretation, understanding of Islam under the interpretation of the Ahli Sunnah wal Jamaah, under the Shafi'i sect as practiced in Malaysia or in Southeast Asia. So for the communist terrorists, the cities or operators of the CPM, for the RSF, or even for less hardcore members of Al-Mauna, it was much easier to engage with them. In fact, what is interesting that I had a personal experience when I was a second lieutenant in 1980, because the communist terrorist movement or Communist Party of Malaya and the government of Malaysia and Thailand signed a deal on December 1989, whereby they put down their weapons and they were placed in settlements in southern Thailand. You do not find this in the book. So they were placed in settlements in southern Thailand known as peace villages. They are Malaysian citizens, but they chose not to settle in Malaysia. Both governments, they had to sign an oath that they will not undertake armed action against both Malaysia and Thailand. So long they are peaceful, they will be placed in these settlements, and they were given means of sustenance. They were given financial aid and also a plot of land for them to stay and to work on. And when they are ready, then they are accepted to join the general population of Malaysia and Singapore, Malaysia especially. Now, what is interesting is that with the cities or really the members of the CPM, it is quite. It was a relatively simple way, to engage with them. Meaning to say that because they aspire worldly aspiration, they are humans. They want to find. They need to fulfill their worldly needs, right? However, with the religious oriented groups where they complicated. Hence, the psychological operation or the psychological approaches under the direct steps were undertaken. It is a step still work in progress. But what is interesting under this step, under the direct process in Malaysia at least, it is multifaceted. Not only religious guidance is being given, or rather being applied, but also that financial aid, education aid also is provided to the families of the detainees. Of course, one of the we'll call it the aspect of it is continuous monitoring. So they are being continuously monitored by the Royal Malaysian Police until they are deemed to be no threat to the society. In fact, under the Prevention of Terrorism Act, even under the SOSMA, there will be a periodical revision of the status. There's a board established under these two laws where individuals who are arrested under this law for their beliefs either they can be reviewed or the status whether eventually are they a threat to society or not. So, in other words, ladies and gentlemen, the method employed, I would not address exactly about IHL, but in terms of practicalness, in terms of operation, it was easier to deal with the members of the CPM. Right? They had a military discipline about them because of their experience during the Second World War. I had a personal experience when one of the deals of the laying down of arms in December 1989 was they endeavored to show us the position of minefields, booby traps, and arms caches, and they cooperated with the military. I escorted them in the jungle for them to show me, for us to recover the location, to mark places of landmine being placed. So regardless, it's a still ongoing process. It is not perfect, ladies and gentlemen, I would say that. So the prospect is this, that it is much easier to deal with those groups where they aspire ethno-nationalist aspirations. I'm using an international relation term. So ethno-nationalist means they basically the concept of human security, security of personal security, security of economics, security of job security, and all those things. Right? But if a group expires a non-worldly expression, that becomes a challenge to the authorities. And if you see through the figures, through statistics, Malaysia has been spared the worst vagaries of other nations. At worst, of recent memory was the lobbing of grenades into a entertainment establishment in Kuala Lumpur in 2015 by members of ISIS. We were spared the rest, unlike other countries. With that, I thank you. Thank you very much. Over to you, Dr. Umi. Assalamualaikum.
Waalaikumsalam. Thank you very much, Colonel Azlan. Now I'll pass the floor to Mr. Dominic. Over to you, Mr. Dominic.
Hello, good morning, everyone. Just give me one moment to load my presentation, and then we can get going. Okay, here we go. Can you all see that okay?
Yes.
Yeah. Okay, so thank you all. There were a number of fascinating presentations setting out the legal framework. Now, in my presentation, I'll be talking a bit about how the ICRC and indeed other humanitarian organizations engage with non-state armed groups to promote the respect for humanitarian norms and international humanitarian law, depending which is more relevant. I'll be speaking more broadly here rather than just about Malaysia, because I guess fortunately we don't have much experience dealing with non-state armed groups in Malaysia, because there aren't any. So here we go. I'll just have a quick look at what we're talking about when we're talking about non-state armed groups. Here in Asia, I will focus on, we're dealing with many ethno-religious nationalist groups, thinking about Southern Philippines, Moro Islamic Liberation Front, Moro National Liberation Front, Southern Thailand, Myanmar, a host of ethno-nationalist groups. We still have some leftist groups fighting in our region, not as many as 30, 40 years ago, but still New People's Army in the Philippines, as was mentioned earlier, a number of Maoist groups in South Asia, the Naxalites in India, the Maoists in Nepal until quite recently, Taliban groups, Obviously, Afghanistan, the Afghan Taliban, one of the most powerful armed groups in the world probably, and now in a peace dialogue. And the Taliban in Pakistan, the TTP, which over the last year has been growing again, restarting activities, expanding. And then we have more diffuse groups which may not reach the classification of a party to a non-international armed conflict. So we may be talking more about other situations of violence, but still operating in an organized form. So Islamic State networks, as mentioned, we have all across the region, mainly as diffuse networks of cells, not reaching the level of non-international armed conflict, but in some places, such as Afghanistan, Islamic State Khorasan, in the Philippines previously, we have more organized armed groups controlling territory and classified as parties to the conflict. Al-Qaeda networks, again, mainly networks operating in other situations of violence, and assortings of tribal groups, if we think to armed violence, particularly in the Pacific. In Papua New Guinea, we're dealing with many tribal groups, which, though not reaching the level of an organized armed group in a non-international armed conflict, are creating another situation of violence with considerable humanitarian consequences, and where humanitarian norms are therefore of key importance. So, when we talk to non-state armed groups as a humanitarian actor, both for the ICRC and many other humanitarian actors, we have a number of topics. The key one is often, the initial one, is acceptance and security for humanitarian action. So if you want to deliver humanitarian projects, whether that be health projects, delivering water supplies, food, if you're dealing in an area either under the control of a non-state armed group or where there's a heavy presence of non-state armed groups, they need to accept you and provide security, because obviously these groups are armed and can be dangerous. If they don't accept you, maybe you could be attacked, killed, kidnapped. So a first step of engagement is accepting of humanitarian action and the presence of humanitarian acts. Moving on from that, it's working out particularly where they control territory, how can services be provided in that territory. For example, in Afghanistan, you have large swathes of the country where the Taliban is the government and people have humanitarian needs. Like people in the government areas, they need health, they need water, they need food, and therefore we need to sometimes treat armed groups like we would treat the government when operating in their territory. And then coming on to the international humanitarian law and humanitarian norms, we want to have dialogue to make sure that the groups are aware of the relevant legal bodies. If it's a non-international armed conflict, IHL, if it's not reached the threshold of a NIAC, if it's still another situation of violence, maybe more broad humanitarian principles, humanitarian values. So a while ago, we did a survey to look at when we talk to armed groups, what are we talking about? So in each conversation with an armed group member, we found that 85% of the time we are discussing access and security. So this nearly always comes up when we talk to armed groups. Can we operate safely in their areas? 29% we talk explicitly, 29% of conversations with armed groups involve implicit discussion of IHL. This may be in terms of training or it may be interventions where we say that their group, we believe, has not been respecting IHL. And then 50%, around half of conversations, involve some protection issues. So this means where the conduct of hostilities, where the non-state armed group has been involved, we usually may have put civilians at risk in various ways. This is maybe by direct targeting of civilians or lack of precaution to take care of civilian structures. Attack on hospitals is a big one, healthcare in danger, medical mission not protected. So we're very often talking about these things, and you can see sometimes we'll reference IHL. Sometimes if we feel this is not the best strategy to get the message across, we may talk about protection issues without explicitly talking about the legal background, maybe just the moral case for not attacking a hospital, for example, depending on the group. And it may well be one of these groups where it's not reached the threshold of a NIAC, so IHL may not be the most directly relevant code. So now, how do we engage? This varies very much. We engage in a number of different ways, often depending on the group and the context. If we're talking about an organized armed group that functions like a state military with clear hierarchy, clear control, like the one you see in the picture, uniforms, etc., then often we can talk to the hierarchy, we can talk to the commanders, like we would when we go and meet an army, a state army, and it's quite straightforward. Other situations is more complicated. There may be reasons why either the group doesn't have a proper hierarchy we can talk to, or we cannot access them for security reasons, maybe our security, because where they are is too dangerous for us, or their security. They believe if they meet a humanitarian actor, it may put them in danger from the state authorities. They might get droned afterwards, so may not be willing to engage directly. So we have to use other methods. Intramuros, this means sometimes we end up meeting key leaders of armed groups during our detention activities. When we visit prisons to look at conditions of detention, we will meet them, and this can allow us to understand how they view humanitarian norms, humanitarian action. Religious circles can be very important. Obviously, the religious groups often have a very close relationship to the people. Think of your village priest, your village imam, the monks in a temple where the conflict is going. They're often from the same community, understand what's going on, and can work to influence. Same goes for tribal leaders, local politicians, civil society. Civil society in conflict zones can often be very well connected, able to pass messages to the different actors because they're people from the ground. So working with them on humanitarian principles and humanitarian actions can be a good way to reach the armed groups. Also business links, especially if a group is controlling territory, businessmen still want to work. They send in products, they send in items, they often have a good understanding of what's going on the ground. So, so how do we work with to persuade non-state armed groups to comply with IHL principles? As I mentioned, we have two major routes. The legal route, if we think this is the best, we're explaining the law, making sure they understand the law, how it applies to them, and making sure that they themselves should put in sanctions for when their members do not comply, and that they understand there are some international sanction mechanisms, such as the International Criminal Court. Other times, it's moral argument, and often a combination of the two. We may not be referencing the exact code of IHL, but talking about the moral principles of mercy, of respecting civilians, respecting ordinary people. And this is a very effective way to talk to groups. So, in practice, why do some non-state armed groups fail to comply with IHL? Often, ignorance for a start, a lot. I've seen this in person, a lot just don't know it exists. They don't know this body exists, they don't know that they are subject to it. So obviously if they don't know the law, it's very hard to follow it. Sometimes the rejection of the law, they don't see it as relevant to them. Why do I care about these Geneva Conventions? I'm fighting somewhere else. We have our own legal codes. And a host of other things, their religious traditional codes may be more relevant. Sometimes the group leaders may understand the importance of IHL, but they don't have the sufficient control or resources to teach it and control their troops. Very much depends on the nature of the groups. So a whole reasons why it could be, why there are failures in compliance. And then why do some NSAGs able to do it? Sometimes they believe that this is not necessarily true, but sometimes they believe that if they follow the law, it will give them, they will be more able to speak on the international arena. If they're engaging in peace talks, they may want to be seen as a respectable actor, differentiate themselves from terrorist groups. Some groups, they've been able to educate themselves on their legal obligations. They have the command structures in place to be able to set up training programs. They have good control over the fighters, or often we see that that other actors can help influence them. The religious leaders, the traditional leaders, community leaders can help to pass the important messages of IHL and humanitarian norms, and sometimes not in the legal sense of reciprocity, but in the practical sense. They may fear that if they mistreat their enemy may mistreat them in terms of treatment of detainees, treatment of prisoners of war, this kind of thing. So what we've seen though in the past couple of decades, and particularly accelerating in the past 5 or 6 years, is a real change in the nature of conflict. This really started since 2001, since the so-called war on terror. We've seen a much more diffuse pattern of conflicts. So we now, ICRC now classify more than double the number of conflicts than we did 20 years ago. And we're seeing more and more conflicts have a multitude of non-state armed groups. It's less and less a case where you have a government fighting one very organized hierarchical armed group, and more a case of, so we have 66% of conflicts. There's more than 3 different armed groups. which obviously makes it much more complicated to ensure that all of them understand and apply IHL. Often the groups, they splinter, often they form, they merge, they assemble. So it's a very, very complicated environment. Often think of Syria, think of Libya, and the plethora of armed groups that are acting in the field, and the challenges of ensuring they all understand their legal obligations. So with this in mind, the ICRC a few years ago launched a new study, which was published, I think, last year or the year before, I forget, called The Roots of Restraint in War. So this is to understand, it looks at both state armed forces, the armies, I think it studied particularly Australia and the Philippines Army, and non-state armed groups, to understand why in war sometimes groups basically show no mercy, do not respect humanitarian norms, kill their enemy, terrorize civilians, where other times they show restraint. Even in difficult situations, they choose not to kill the civilians, not to rob the hospital, to choose to behave in a humanitarian way. So this study was launched to look at the major factors. I won't be looking at the state forces now, I'll be focusing on non-state armed groups. But in the study, they ended up dividing non-state armed groups into three broad categories: centralized, decentralized, and embedded. Obviously, in practice, these are not always super clear. Sometimes groups are on the boundaries or show features of multiple factors. But centralized, we're talking about groups with a clear hierarchy that operate very similar to an army. They have clear commanders, a bureaucratic system, uniforms, discipline, training methods, organized training for new recruits. And with these groups, we found very much, this was based on former studies we did on behavior in war, that with these kind of groups, the most important thing is integration of IHL. So the leadership, they understand IHL, they set up training programs, and they set up disciplinary measures, sanctions measures for when their troops do not follow the law. So this is quite clear, but more and more we're seeing these decentralized groups where it is one group operating in one banner, but in practice it's mainly made up of a number of small groups with a local sub-commander who coordinate, but there's no one really in control. The sub-commanders are basically lords of their own area, so there's no one who can say you must all follow the law, you must all stick to the same code of conduct, the same training. So it's much more complicated with these more diffuse decentralized groups. And then we have also embedded groups. These are groups that are basically members of the community that are fighting to protect their community along with their tribal laws often, or with very local embedded in their villages. So to represent this visually, we have the centralized non-state armed groups, clear organization, quite similar to state armed force. And these mainly found when you have one of these that's fighting, it's mainly clearly a non-international armed conflict. Then we have the decentralized groups. You can see these are patterns of small groups of fighters linked together, but not really forming a homogeneous whole. These could be found, a group like this could make up a non-international armed conflict, but it may not meet the criteria of organization. So you may be working in another situation of violence, where you have significant violence, but not a non-international armed conflict, and therefore no IHL. So these groups could be operating in both NIAC or OSB, and the community-embedded armed groups, where it's mainly another situation of violence. So when we look at compliance and influence, like how to get these groups to follow IHL, or if IHL is not relevant, the relevant humanitarian norms principles. With centralized non-state armed group, it's more about compliance. They understand the law, they comply with it, and will be punished if they don't. With decentralized groups, you may be able to work on this, but it's weaker. And with the very diffuse groups in their community, this is really not so relevant for them. Now we look at influence. This is the influence of their local and religious traditions that often have a very developed ethics of the use of violence already, whether this is Islamic ethics, Buddhist ethics, tribal ethics. And with centralized armed groups, this also works to support compliance, but it should be a supporting factor for compliance. With decentralized armed group, this can be quite important. Who does your little local commander with 12 people listen to? You know, the law that he's able to understand, or his local imam, his local monks who are telling him that this behavior is not ethical. And with the community embedded groups, we found it's really the local influence that makes a difference on respect for humanitarian laws. So with these with these local groups, what's important is working very much with traditional leaders, local religious leaders, community debates, getting the community to have their influence on them, local religious and customary practices, and traditional norms relating violence and restraint. So often, how the ICRC or similar organizations can work with this is we can look at, we have IHL, and IHL will always be the law when it's a non-international armed conflict, but there may be ways we can work with these local traditions to make IHL more approachable, more acceptable, so that people feel, people feel they're also doing it because this is their tradition, these are their ethics, these are their values, and this can help to support the understanding of IHL. This is why more and more we're looking at comparisons with IHL and religion, IHL and Islam, IHL and Buddhism. We had a big event on last year. Next year we'll be doing a big academic conference on IHL and Hinduism, looking at how these local traditions interplay with the law. So in conclusion, the major findings we got is that often, depending on the nature of the group, transmitting humanitarian norms and rules of behavior in war, an exclusive focus on the law is not as effective as influencing behavior as a combination of the law and the values underpinning it. So more and more we're working to link the law with local norms and values and give it greater traction and to help individuals internalize and socialize it. And this very much depends how the best way to engage the group is, depends on a very deep understanding of the local context, the local culture, and the nature of the group to decide which is the best and most effective approach to work on humanitarian norms. So we're also working very much on the study of this. So if you're interested, there are a number of different publications. The one on the left, the Hukum Perang Islam, is obviously the law of war in Islam. This was a book written by Ahmed Al-Dawdi, a professor at Al-Azhar, who has since joined the ICRC in Geneva, and is now, as you can see, being translated by the ICRC into multiple languages. And this we work with, when we're working with Islamically based groups, we often work looking at international humanitarian law, but also showing how many of the principles in IHL are not foreign. They were already there in the law of conflict in Islam, and we have the same in Buddhism. And then we also have with, for example, tribal laws. This next publication, which you can download for free under protection of the Palm, looks at wars in the Pacific or conflict in the Pacific, which, while it may not reach the level of non-international armed conflict where IHL applies, still has considerable humanitarian impacts on the community in these places due to the chronic nature of the local warfare. So the ICRC has worked on a study looking at tribal rules of the use of violence, ethics in the use of violence in these communities, and then comparisons with the relevant principles of IHL so that we can try to engage groups engaged in fighting in the Pacific to respect certain humanitarian norms. So, in conclusion, the character and structure of the non-state armed groups dictates the best approach, how we work to it on humanitarian norms. IHL can be socialized, which may be necessary with more decentralized groups, and particularly in situations which don't meet the level of a non-international armed conflict, but where there is a high level of violence, this is crucial. And in certain situations, local customs and laws may be even more influential on groups than is the international law. So thank you very much. And just to say, if you want to read the study in full, The Roots of Restraint in War, it's also available on our website. If you just Google Roots of Restraint in War, ICRC, and you will be able to get it. So thank you very much.
Thank you very much, Mr. Dominic. Thank you, Dr. Aisha, Professor Shaham, Dr. Pardis, Mr. Azlan, and Mr. Dominic. Ladies and gentlemen, we have now come to the question and answer session. We do have a few questions from the participants. The first question is about, we have a few questions on the topic of engagement, engaging the non-state armed groups. With respect to the, during the discussion, we have seen that there are several measures that there are several strategies that can be adopted in order to deal with the non-state armed groups. Therefore, the first question is with respect to what is the best practices to counteract with the non-state armed groups? So I will address this question firstly to Mr. Dominic.
Okay, I mean, we as the ICRC, being a neutral organisation, I mean, we would not be trying to counteract them as such. I mean, we would always take a neutral position on whether the actions of the non-state armed group are legitimate or valid. We're only looking at the humanitarian sides. Where for us as a humanitarian organisation, we engage with non-state armed groups is just on their behaviour, whether they are following international humanitarian law where applicable, or relevant humanitarian norms, or in some cases international human rights law. So, as I was saying, we would look at engaging them only on this matter of their behaviour and its compliance to humanitarian laws, but we would not engage them to try and, leave the conflict, build peace, because this is not the rule for a humanitarian organisation. This would be either for the security forces or peace-building organisations. So we would look at how we can influence their behaviour to make sure they do their best to protect civilians, protect civilian structure, allow key civilian services like health services to go ahead. And also we would look at engaging them on how they treat detainees. I didn't have time to talk about this, but often non-state armed groups will keep prisoners of war, members of the enemy that they have captured, often state soldiers. So we would also engage them to make sure that these people are treated well, not tortured, not executed. And they may also have justice programs for the community living under them, run their own prisons, courts, where we may also look at engage with them to ensure that they are treating people humanely. But this would be the extent of the ICRC's engagement. And as I discussed, how exactly we do it depends on the nature of the group, how easy they are to access, how much control they have, and then we would build a strategy to see how we think is the best way to influence them for them to behave in a humanitarian manner. Thank you.
Okay, thank you. I would like to pose the same question to Colonel Azlan. What is your thought on this question, Colonel Azlan?
Well, one of the most important strengths or stands taken by non-state armed group is their legitimacy. Legitimacy in front of whom, right? They have an audience, right? So one from my previous experience, right, on missions, that all non-state armed groups strive to establish their legitimacy, the legitimacy of their organization, legitimacy of the struggles. Now, what I often preach to my former students in various institutions is that compliance with the law is one of the facets of the road towards achieving legitimacy. For state forces, when state forces embark on operations at the behest or on behalf of the state, of the government, right? The often quotation will be, war is an extension of politics by other means. Whether it's a NIAC or IAC, it is immaterial. Right? So that appropriate observation of IHL rules or IHIR rules facilitate that legitimacy of struggle. Each side to a conflict will often say they are the good guys, the other side is the bad guys. So what is the clear and conclusive evidence to show that either side is a good guy is by complying with law, be it IHL or IHRL. On a matter of torture, I like one important point brought upon by my colleague Dominic, that often we read or come across reports where torture is used as a priori in dealing with detainees, especially with non-state armed groups. Now, from experience, anecdotal experience from sharing examples from other militaries or other conflicts, torture is one of the most inefficient way of gaining trust and gaining, most importantly, actionable intelligence, actionable information. And if you look in our history, when we dealt with the CPM, one of the established advantage undertaken by Malaysian authorities was the ability to turn detained CPM members to work for the government, to become informers. And now torture is not used. Right? So once again, I will put a note here that this legitimacy includes using the moral argument. All right. So once one employs torture, all right, then that morality argument has gone, they're lost. All right. For state forces, basically they have lost 50% of the battle. All right. And then another point by state forces in dealing with populace is that that the population must not be victimized or be seen to be victimized. So I would say that the takeaway that the most important part is for legitimacy based on morality, based on compliance with the rules of the law. Thank you. Over to you, Doctor.
Thank you very much, Dr. Azlan. Since we're talking about engagement, we do have a few questions on engagement. So the first question is, does ICRC need permission from states to have dialogue with the non-state armed groups? And the second question is, how does the work of the ICRC connect to the approach of responsibility to protect? So I would like to pose these two questions to Dominic.
The ICRC will always work transparently with authorities. Tell them what we are doing, explain why we need to have contact with all groups. There's a real humanitarian need for the ICRC to be able to talk to all parties to the conflict, both to ensure that we're able to deliver humanitarian assistance and to ensure that the parties to the conflict, the non-state armed groups, understand their obligations under IHL or the relevant legal code. So in practice, we try to be transparent. We tell them that we are talking. Obviously, we don't tell them what we talk about. For the ICRC, whenever we speak to relevant parties, our dialogue is bilateral and confidential. So what we talk with the government, we would not tell to the non-state armed group and vice versa. In practice, it is often complicated. I mean, states, I won't go into details of which states, but states are often very nervous about foreign organizations talking to non-state armed groups on their territory. So in practice, this can be a constraint for humanitarian action, that we want to reach non-state armed groups, talk to our IHL, deliver services, but are obstructed by states, by governments. This is a big, big challenge for humanitarian action in many parts of the world. Because obviously some states fear that this kind of action could give legitimacy to non-state armed groups if they start dealing with international organizations, and for various reasons would prefer we don't. But we do try to work in transparency. So sometimes the states might not like it, but sometimes we can present that the reasons why we are doing this, that this is really a humanitarian necessity to do this. To meet with all parties to the conflict, and is a really key for neutral, independent humanitarian action. What was responsibility to protect? I mean, responsibility to protect is more of a state doctrine rather than something for the ICRC. The ICRC, I mean, I'm not a lawyer, so there's probably someone here who can answer this better than me, to be honest. But for the responsibility to protect, as far as I understand, is more something that's binding on states, to allow them to step into situations in other states when there are clear humanitarian needs. The ICRC we will always, when there are humanitarian needs related to conflict, the ICRC will always make an effort to be there. This is not always possible. Again, states do, particularly for non-international armed conflicts, states are able to prevent us from operating, but through negotiation and dialogue, we are usually able to secure access and to reach people in need. But the responsibility to protect, as far as I understand, is more about allowing the responsibility for states to step in to put an end to severe humanitarian situations of severe humanitarian danger.
Right. Thank you, Dominic. We have a few questions on the classification of the armed conflict, and how do we classify the non-state armed groups? So I would like to pose these questions to Dr. Aisha. So the first question is, how do we distinguish between non-state armed groups and terrorists? Because under plain understanding, both of them carry the same agenda. And then the second question is, having a political agenda is crucial in distinguishing non-state armed groups and non-state armed groups. However, where does this factor comes from? Because if we look at the Tadish case, in order to classify whether situation is non-international armed conflict or not, then we have to look at the organization test and the level of intensity that you have mentioned just now. Can you, I would like to pose this question to Dr. Aisha.
Okay, thank you, Dr. Umi. Okay, the first question about should we classify first whether there is an NSAG or what kind of conflict do we have under IHL? It's both. Okay, it's important. Remember, when we study IHL, we have to make the correct identification in order for us to identify also the kind of IHL application for the type of conflict and who are the protected individuals and organizations under IHL. So we have to consciously identify both correctly. Okay. Second is that in terms of political agenda, terrorism. Okay, as I mentioned, there is no agreed international definition of terrorism. So in the case of non-state actor groups, okay, there are non-state actor groups that sometimes may be labeled or categorized by international community, like the US. They would have, or the European community, they would have their own list of terrorist organizations. Then they, other people may follow, look at that list. Okay, but there are also those non-state armed groups that are not part, that's not fall on that list. But then at the same time, maybe this particular question is applicable to the Malaysian setting, where we do have some presence of small groups that are identified with acts of terrorism. Okay, like ISIL or ISIS-linked organizations in Malaysia. Nonetheless, they have not yet reached that level of a non-state armed group, mainly because they are not, they do not have a structure, an armed structure and presence, and they do not control a territory. In terms of political agenda, that's also something that is clear that not only non-state armed groups have political agenda, even terrorist organizations also have political agenda. So that is one criteria that, we can also apply. Okay, but more important is that for all these small organizations that may have some affiliations with terrorist organization or that kind of organizations in Malaysia, they cannot pass the test of being a non-state actor group because they are not in a control, in the territory of Malaysia. So that is one. And in terms of defining, there's another question, Geneva Convention. Okay, I think, yeah, that's it. I think I've already answered, where does political agenda come in? But maybe I would like to add another point in the definition that I offered, this idea of this statement about low minimum threshold of casualties, or when do we say that there is an intensity of the conflict? There is an minimum intensity of the conflict. This is also something that is a bit difficult to explain because even in the IHL, there is really no clear definition of how do we actually say that there is a certain level of intensity of a conflict. Is it number of casualties? In terms of number of confrontations, there is no specific level on that. So it's very much debatable. So far, in terms of scholarship, the Uppsala data based in Sweden, they have defined this idea of minor or low intensity and low intensity conflict and major conflicts. And the threshold is 1,000. So they say armed conflicts that have casualties below 1,000 per year, then those are minor conflicts or low intensity conflicts. But for those conflicts in a year that have more than 1,000 casualties, then these are major conflicts. But then again, in reality, as Mr. Dominic mentioned, a lot of the security threats, okay, that we have in the world today. A lot of them are coming from intrastate conflicts where it involves non-state armed groups or NIAC situations with NSAGs. Okay. And sometimes the intensity of the number of casualties may not even reach that threshold. Like, take for example in southern Thailand. Since the beginning of the southern Thailand, they have several armed groups. Okay, so since 2004 up to today, the recorded number of casualties is still it's at 7,000, and that's from several years. So it doesn't. So that's why it is a low intensity conflict. It cannot even reach less than 1,000 per year. So a lot of things are still debatable, but at the same time, given the situation that we have in each country in terms of who are the groups that are really sustaining this revolutionary organization in order for them to achieve a political agenda, and they have been able to control or to have influence in the security situation in that country, then it should be easier for us to identify who are the non-state armed groups.
Thank you, Dr. Aisha, for the explanation. We have a few questions on the rules applied to the non-state armed group, especially in Malaysia. I would like to address this question to Prof. Hisham. The first question is, reading the Interpretation Acts with preamble of the Geneva Convention Act, could it be said that our 4 Geneva Conventions are deemed integral part of the Geneva Convention Act and incorporated under Malaysian law, in addition as reference for the purposes of Section 3?
Okay, thank you for the question. The purpose of a preamble to a statute is to assist when the wordings in the provisions in the Act is ambiguous. Okay, and also to clarify what is the meaning. What is the meaning? So basically, that is the role of a preamble. Here in the Geneva Convention Act, there is nothing. There is nothing. Okay, saying that this act gives effect to the conventions listed in the schedule. Okay, so I'm not really sure. That's why I'm saying I'm not really sure whether this means we are incorporating we are transforming the law in the Geneva Conventions because they are listed in the schedule. But if we are, then why is there no such provision? Okay, in the Geneva Convention Act. Another thing, we have looked at the fact of Section 3 just now, where Section 3 criminalizes grave breaches as in certain articles in the Geneva Conventions. For example, Article 50 of the Geneva Convention Act. Whereas the Geneva Conventions have hundreds of provisions, but what is being given effect is one provision from every one of the 4 Geneva Conventions. So to say that reading the preamble together with the Interpretation Acts, I'm not really sure that it means that the Geneva Conventions are now parts of Malaysian law. As Dr. Pardis mentioned just now, Malaysia, we apply the transformation doctrine. We are a dualist state. We need to transform the Geneva Conventions. But that's not normally how we transform the treaties that we become parties to. I have mentioned just in the presentation about how we transform the provisions in the Vienna Convention on Diplomatic Relations. Similarly with other conventions, such as Convention on the Law of the Sea, we have transformed that into several acts, such as the Exclusive Economic Zone Act. Okay, we do not put the UNCLOS in the schedule, for example. So this is a different style. So I'm not sure what you believe. I'm sorry, I couldn't answer with certainty on this.
Right. Thank you, Professor. Another question on the application of Malaysian law in dealing with the non-state armed groups. Can the penal code be used in lieu of the absence of specific legislation in prosecuting those people who has committed war crimes?
The penal code can punish up to a certain extent, but will not be appropriate provision. Let's say someone targets civilians, that is war crime. Let's say we charge that person, the one who targets a civilian, for murder or for causing grievous harm, grievous bodily injury, for example. Yes, we can punish them. We can punish that individual under that law, but to punish the person not under war crimes means to say that we are lessen, we are belittling the crimes that have been committed. It is crime. It is war crime, part of international crimes. It is heinous. Okay, but we charge for murder. We charge for causing bodily injury. That is not appropriate. Similar with, let's say, someone who commit genocide. Someone who committed genocide, and we charge for multiple murder. That is not appropriate. Okay, although the person can be punished with death sentence in Malaysia, but he will be found guilty only of murder, not because of genocide, for example. So this is the thing. War crimes, crimes against humanity are heinous crime. The person should be punished appropriately, not some other provisions under the penal code or under any other Malaysian law.
Right. Thank you, Prof. Prof, for the answer. We do have a few questions on the legitimacy of the non-state armed groups, and Dr. Pardes mentioned one point which is very interesting with respect to the non-state armed groups. They can be considered as the subjects of international human rights, international humanitarian law. So the question is, do states want to integrate with the non-state armed groups? For example, the non-state armed group should comply with a certain standard to establish a detention camp for those people that they have detained. And I would like to address this question to Dr. Pardes, because when you mentioned just now that a non-state armed group should be considered as a subject of international humanitarian law, does that mean we are now recognizing their legitimacy?
Thank you for the question. I understand your concern. It's true that international humanitarian law, it's a good good instruments in addressing the problems and the violation of non-state armed groups in the absence of international humanitarian law. And definitely non-state armed groups have their obligation. And as I stated in the presentation, there are international instruments, including international, regional, and some resolution, UN Security Council resolution, which abide non-state armed groups to comply with these rules. And definitely they need to comply with the rules of, based on these international treaties. And in case that they don't comply, there are some possibility, there are some sanctions which could be imposed to non-state armed groups. And definitely when we say that, when we explain that there are some regulations to address these non-state armed groups, it doesn't mean that we confirm their legitimacy. The legitimacy is at the at the center of the question. But international humanitarian law draft, and especially UN Charter, UN Security Council come up with a resolution to address the violations of non-state armed groups.
All right. Thank you very much, Dr. Vardis, for the explanation. I would like to pose the same question to Dominic. Through your work, the ICRC engagement with the non-state armed groups, I think one of the question which is asked by the participant is, beyond the legitimacy argument, ICRC convinces, this is the reply made by Professor Dr. Aisha, but in relation to the engagement with the non-state armed groups, do you think that by engaging the non-state armed groups, somehow the ICRC is providing them with some sort of legitimacy? Yeah.
Yeah, I mean, IHL is, it's a really basic doctrine that everyone involved in a conflict, whether a non-international armed conflict or an international armed conflict, has to follow. So it gives them no, it doesn't speak, there's no political element in it, it doesn't speak about the, the legitimacy of their cause, the righteousness of their cause. It doesn't have these kind of human rights elements like, right to use your own language, right to self-determination that a lot of the armed groups may be basing on. None of this is present in IHL. It's only on the conduct of hostilities. So there's nothing inherently political in it. So this is why we think, it shouldn't be a threat to states, thinking that if their opponents, the non-state armed groups, apply IHL, it will give them legitimacy. This doesn't mean, non-state armed groups don't think that, in general, being party to international treaties, engaging with international organizations, they may have this belief, but we don't think there's anything in IHL that is political or builds political legitimacy in terms of broader armed struggle of who should have political control. I mean, it's really a very basic set of laws about conduct of hostilities and how you treat the civilian population and your enemies. So we don't see this as a threat.
Thank you very much, Mr. Dominic. One last question before we close the Q&A session. How about private military and security company? Do we consider them as a non-state armed groups? So perhaps I would like to pose this question to Dr. Aisha.
Yes, again, can you repeat that? No
how about private military and security company? Do we consider them as non-state armed groups or not?
I like that question. Thank you. Okay. We have witnessed over the years, especially in armed conflicts in the Middle East, in Iraq, Syria, Afghanistan, mainly the US government and the US military forces have been hiring and engaging private security forces. One of the more popular ones will be Blackwater, that they have appointed in Afghanistan and Syria. And the function of these security forces can be in terms of civilian work. They can be cooks, secretaries, helpers, or they can also be security guards. Okay, what is the commentary of ICRC in regards to this new development? In that, if in any case these security related individuals are part of the conduct of hostilities of the US military forces, then they fall as part of the security force of that government. Okay. But in any case that they are civilians, okay, they are just security guard. I think if they are security guard, they are part of the hostilities. They are part of the hostility activity. But if they are cooks or secretaries or helpers, then they are treated as civilians in that case. Yeah.
Right. Okay, thank you very much, Aisha. I believe that we are.
I hope Mr. Dominic is satisfied with the answer.
Oh yeah, maybe before we can get last comment from Mr. Dominic before we end our session.
Yeah, as Aisha said, a very, very, very good full answer. I mean, it really depends on what role they're playing. Obviously, if you have private military companies acting basically as a mercenary force where they've been hired by a state to complement the armed forces of that state, then they wouldn't be classed as an NSAG, but they would be classed as party to the conflict, as they are under direct participation of hostilities with one of the parties to the conflict. So again, I'm not a lawyer, so don't publicly quote me on this, but this would be my understanding that yeah, they would be considered as an auxiliary to the main party to the conflict if they were under their command and control. Maybe Priscilla might jump in to help with the legal side.
All right. Because of time constraints, I think we shall end our question and answer session here. I would like to thank you. I would like to thank all the speakers and the participants for the excellent discussion. On behalf of the Faculty of Law, University Technology Mara, and the ICRC, I would like to thank all of you for attending this virtual roundtable discussion. Ladies and gentlemen, it looks like our event today has come to an end. But before we can call it a day, let's have a photo session together. Yes, so please be ready. Please open your camera, everybody. Sarah, are you ready?
Yeah. On the count of 3, Dr. Pardis. All right. Okay, on the count of 3, be ready, everyone. 1, 2, smile. All right, one more time. 1, 2, 3, smile. All right,
Yes,
thank you.
Thank you very much, everyone. Thank you for joining us today. I hope you have a pleasant day ahead. Assalamualaikum and a very good afternoon.
Bye.
Thank you. Thank you, everybody. It was a pleasure.
Thank you.
Thank you. See you all. Bye-bye.
Thank you.